Hello, I am here with Brad Hunter Casey from Regina, Saskatchewan, and really super excited to be working with you on this project, Brad. And I'd like to take a few minutes just to have a chat with you, given your experience as a litigator and interacting with the court system, knowing that people are watching this video or actually watching because they're contemplating doing something different. And wondering if you can highlight what are some of the main differences between going to court compared to working in the concierge collaborative process.
Well, Charmaine, I've been a lawyer for a very long time, and I've run in excess of 100 divorce trials over those years. I am trained as a mediator, and I was one of the first collaborative lawyers in Saskatchewan because of the futility of the court process. And I'm no longer going to court, but I've learned a lot over those years. First thing I would say is because of certain legal changes, you have to attend mediation or collaborative law before you can get to court in the first place. So it seems like it's the place to start. But I often think that people, when they're divorcing, especially if there's tension with their ex-spouse, just don't know what to do. And by default, they end up in a court process because they go see a lawyer, and every lawyer tries to do their best, unless they're offering options such as collaboration. You don't often get into a process you don't know or you don't understand.
And so what is it that, first of all, just like that requirement now to have to do something, like what do you think is behind that? Why would that be a requirement?
It's always been the case that virtually every case settles. 98 out of 100 settles. So you're going to settle, but if you go into a court system, it often delays, increases the costs, and increases the conflict. So the idea is everybody is going to settle their case. That's not true, but it's almost true. So that's why you want to start here. And the people who end up in court, they'll end up there. But part of it is just that recognition. And that's also the recognition that the kind of conflict that ends up happening and developing is very destructive to the people involved and to their kids, if they have kids involved in the divorce. One thing that's really clear from all of what we know about how divorce affects children is that if the parents go through the divorce and are able to work things out and have a cooperative relationship, the kids do pretty well. And if they don't, if there's a fight, the kids do badly.
Yeah, and you mentioned, it's eventually people settle even when they're in the court process, but what does that look like from a time perspective?
Well, there's a few things that happen. First of all, you lose control of the timing if you go into the court process. It's governed by how available your lawyer is, how available your spouse's lawyer is, how much your spouse wants to cooperate. So initially things are slow. You have to commence court papers, they have to be served. If you're going to say try to get temporary child support or a temporary parenting arrangement, that can take months. The next phase can take a year or more, which is getting all the documents you need from your ex and giving them to them, and then going to something called a pretrial conference, which is a meeting with you, your lawyer, a judge, your ex, and their lawyer. And that can take anywhere from 6 months to a year and a half before you go there. And if your case is at all complicated, it can take longer than that. So you get that second big delay. And a lot of cases settle there, but not all do. And if you actually end up in a trial where a judge is going to hear your evidence, that's again 6 months or a year after the pretrial. If you add it all together, you still also have to wait for the judge to make their decision. They don't decide on the spot. They will take often months, at least 2 or 3 months. They want to carefully consider your case, and they have other things to do. You're not their only case, and it can often go longer than 6 months. You add that all together, and you're close to 3 years. And then if anybody appeals, add another year or two to that. So it's 3 to 4 years off if you're going to go to court. If there's a real story about one couple, they were married for a year and a half, and it took 8 years for the case to get through court. It went all the way to the Supreme Court of Canada. So the timing is you almost forget what the issues were from when you started the divorce.
And meanwhile, of course, life is continuing in the background, right? You still have to parent, you still have to make sure your bills are paid and you're maintaining your joint assets. And so it's almost like you can consider you're giving up, 2 years of your life. And how does a collaborative process, and especially what we're envisioning, our concierge collaborative process, how is that going to compare to what your experience has been?
I often say that people who are waiting for their divorce to be resolved are in a bit of a zombie state.
Right.
They're looking at not being able to make any decisions. You can't buy a house often. You don't know if you're going to stay in the house. If you're in business, you don't know what to do. So you have no ability to make any decisions about your life for several months or for several years, but for years often. With respect to a collaborative process, part of our approach is going to be to put this into a 3 or 6 month period where, depending on how complicated the case is, where basically you have a time horizon, you can make some plans and you actively participate in where you're going, but you get 2 years of your life back. And that's incredibly valuable for people. And you can see people who just get exhausted by the stress. I kind of compare it to the medical system where, these days, if you need surgery, and it's not urgent, it can take months or longer to get in to see a specialist, then months more for the tests, months more for the surgery, and you're waiting a year and a half. And then there's the healing process after that. And it's very much the same thing. When you're waiting for this system, you're waiting for the courts, they're a public asset. You have to wait your turn, and that's how long it takes.
And then what about like the costs that are associated with like such a potentially long drawn out process compared to what we're wanting to offer?
Well, the cost is can really spin out of control quickly. The court documents that are required to get a basic court application, believe it or not, are 25 documents that your lawyer will have to prepare and file on your behalf. And that's the minimum. It's usually more, and your spouse will file not quite as many, but just about as many. So the first parts of this can be easily $10,000 just to get a temporary order. It'll take you a long period, months to do it. Going through the pretrial process, you're going to have to spend the cost of your lawyer's day in court, plus them getting ready for it. That adds another significant chunk of money, depending, again, more complicated, more costs. And if you go to trial, the sky's the limit, depending on what you're doing. Most people, in my experience, can't afford my fees. So they end up borrowing from the bank, often borrowing from family, or they take on an extra job just to pay legal fees. So it drains your resources and your spouse's resources, and it ties up your finances just to do that for a total of 3 or 5 years. If you take out a loan, you might have to take 5 years to pay it off.
And I'm guessing you really have no way of knowing even how much it's going to cost.
And your lawyers really can't give you an accurate estimate. They can give you a ballpark if this, but if it's going to go to trial, no, they can't give an estimate. I often would say this is going to cost you between $5,000 and $100,000. And it sounds weird, but in fact, that's often true in the case. And again, if you don't have the money, you'll find it somehow.
Yeah, because it's one of the most important sets of decisions you're ever going to make. So you've got an uncertain timeline, you have an uncertain cost, and then what about your outcomes?
Well, the other thing is you really lose control of the situation, or you lose input. Rather than control, you have to work with your spouse, so you have to work with them, but you lose your input into the situation. Your lawyer's doing a good job for you, but they take it over. So you're simply filing, giving them papers, occasionally telling them what to do, but they're really giving you advice as to what you should do. So you don't have any control. You have very little input. The only time in that process that we talked about where you have a say about what you want is at a pretrial conference. And even then, you also narrow your options once you're in court. There's simply, you get down to what a judge might do. Whereas if you're negotiating, there's a lot more creativity, a lot more you can handle. So you have to compare 3 to 6 months of stress and difficulty and working out all these issues, but being involved in them. And keeping your costs, it's not inexpensive, but they're under control. You get some certainty about your costs with walking away from all that. So although I've done lots of court work and there are cases that will always go to court, there are situations that are too complex. More than that, it's usually there's too much emotion between the spouses that get cases to court. So I have taken the view for a very long time that things need to be done quickly. And I think what we are setting up sets some timelines, set some details, set some obligations on us, and set some obligations on those people who want to get through their divorce. So you'll be able to get on with your life confidentially, because the courts are public, and not all of it, but large chunks of your life could appear on the internet if you're not careful. So there's lots of ways to go about it. But with respect to court and going even, it's just very hard with people.
Thank you, Brad Hunter.